When we were putting this summit together, we were obviously looking particularly at leveraging value in and understanding value in brands and intangible assets, as it's an area which is not that well understood. But thought it would be useful to look at enforcement as well. One of the most frustrating aspects of the IP system, intangible asset system, is that you can spend an awful lot of money and do a great job in obtaining IP rights and IA rights, but they don't enforce themselves. And it's something we get asked about for those who aren't experienced with the system a lot. Why on earth do I have to be the one put to creating or spending a lot of money on enforcing my rights? Why shouldn't the rights themselves prevent others from doing the things that we want to stop? Increasingly, it's harder and harder to find, clear, obtain a novel and distinct brand, and harder and harder to protect it, but easier and easier to infringe it. Growth of the internet, I mean, not so much the growth of the internet, the role of e-commerce, the ease of manufacture, availability of 3D printing, the role of marketplaces, increasing access to huge numbers of people around the world just by a few clicks to place products on marketplaces. Increased privacy around third parties, prevalence of social media in pushing sales of product makes it easier and easier to infringe, even though it's harder and harder to enforce rights. In general, it's relatively easy to protect your physical assets. You know, put some glass around it, build some walls, stop people from stealing stuff, but much harder in relation to intangible assets. And those who are experienced with dealing with brands will understand that when dealing with an enforcement situation, it usually isn't the right mental state to get into, that you're effectively entering into that enforcement to generate some form of financial benefit. It's absolutely essential, of course, for the value of the brand. You know, we heard Kelvin and Fernando talking about valuation of assets and valuation of brands, and of course keeping the mark distinctive, stopping third parties from using rights, stopping them from infringing, stopping them from making money off your assets is absolutely key if you're wanting to maintain value in those assets. Likely also key if you're wanting to maintain the sort of margins that you want to generate in a licensing program. If your brand is diluted, it's less likely that you're going to have an attractive asset for the purposes of licensing. Absolutely essential in relation to the core function of the brand, retaining consumer trust, making sure that the brand is carrying the messages that you want it to, rather than the messages that third-party infringers may be applying to it. But all of those things feel difficult to pin down. The cost of enforcement is often fairly high. Recovery is usually seen as a secondary aspect. You enter into the enforcement proceedings to stop the activity, but often internally, and we hear this a lot from clients, it's felt to be very difficult to justify the spend on the enforcement. But it's interesting. I mean, most jurisdictions, when you look at enforcement of IA rights, do have some form of ability to recover financially, either by way of costs or by way of damages. So it's interesting that that in general, this hasn't been the route that people employ from an enforcement point of view. It isn't the purpose. It isn't the main drive behind enforcement activity. Well, why is that? I mean, in general, and it varies a huge amount from jurisdiction to jurisdiction, of course, enforcement takes a long time. There's usually a fairly significant investment going on from the point of view of legal fees and time, internal management, to deal with any kind of enforcement activity. Usually, the key objective of the enforcement is to stop the activity that's going on, and as such, speed of resolution and spending not too much on achieving that is usually the thing that most people are looking for, rather than the generation of funds. And the fact that it can take a long time to get to a conclusion can often effectively push the fact that a settlement which does not involve recovery of money, but does involve a swift resolution of the issue in question, will likely be high on the agenda for many businesses. Often in relation to brand enforcement, it's been the case that the returns are not really worth the significant input investment of costs and time to justify continuing with the cases in question. Historically, patent cases can be worth an enormous amount depending on the technology, but brands generally have not been seen to be as valuable from an enforcement point of view. But there are a number of jurisdictions where perhaps the tide is slightly turning in this sense. We see a number of jurisdictions where account of profit is available in relation to enforcement. That is certainly the case in the UK from a recovery point of view, and recent cases have shown that that actually this does not need to be directly tied to damage suffered by the IP rights owner, and relatively significant sums can be possible depending on the nature of the infringement and, of course, the nature of the party who are infringing the rights and what they have done. The law in China has changed relatively recently, and we've started to see more significant judgments and more significant awards being made recently in a John Deere case, but also in a case involving Fila. Significant amounts were awarded by the Chinese courts in relation to provision of accounts of profit. In China, it is required, or at least it's a significant part of the decision as to the scale of the award, that willfulness is shown, that it's an intentional infringement. But that recent case has pointed to the fact that bar is relatively low. In that case, the party in question were found to have applied for a trademark, to have failed in obtaining that trademark because of the earlier rights holder, continued with their use, and that was deemed enough for this to be a willful infringement and provide a significant award. In the US, recent case involving Fossil confirmed that account of profit can be provided even though there is an intentional infringement going on. So there's a bit of a shift towards slightly higher awards in relation to brands, in relation to infringement and enforcement. But it's still the case that it's very difficult. So can you make an enforcement program work for you and generate money? Well, it's difficult, but there are certainly ways in which you can improve your chances of doing so. And I'm going to look briefly at 5 there set out on that slide. The first one is just to look at that your enforcement program in a strategic way. I mean, that may seem like a totally obvious thing to do, but often enforcement feels a little ad hoc. What issue is particularly important to the business? What's been notified to the business? My experience is that most significant brands have way more issues to deal with than they have either the resource or the time or the enthusiasm to deal with. You can only have an effective enforcement program if you can prioritize properly, and you can only prioritize properly if you really understand what's out there, and you can only do that by having a decent monitoring program. Increasingly there is decent technology to get a reasonably full picture of who is doing what online and around the world in terms of infringement of your brands, whether on marketplaces or on websites, through social media. Slightly more difficult in relation to physical marketplaces, but still possible. So your strategy has to start with that monitoring in order to prioritize what things you care most about. In order to make any kind of program with any kind of volume work, you will need to use some form of standardization. You can't engage with every single issue as if it is a brand new one. Usually, in my experience, there are only a certain number of different types of issues. And if you can look at and agree a strategic approach, a standard approach to certain types of those, that can really help strip cost and time out of dealing with a lot of different things that are going on. Put together a playbook. put together a way of dealing with certain types of activity in order to be able to deal effectively, quickly, and in as cost-effective way as possible. But even then, that only looks at trying to reduce cost or spread a budget further. It doesn't really lead to generation. I've put on here that your table image is important. I've mentioned that. Some of you may know I quite like playing poker. Table image in poker is absolutely essential. How does another party perceive me and my approach? And what do they know about me as to how I will react? In relation to enforcement for a brand owner, that's also important. Actually, the world is a relatively small one for infringers and counterfeiters, and they soon get to know if you as a brand owner don't take enforcement particularly seriously. You know, are you someone who doesn't have customs recordals, or if you do have customs recordals, you're willing just to destroy the product that gets found by customs rather than pursue the parties who are infringing? It doesn't take much for the counterfeiter or the infringer to realize that actually he might be a soft touch. So some form of strong enforcement that actually impacts on the infringer themselves is an important part of any kind of program. So some form of escalation in order to be able to enforce more effectively against others is a key part of any of these programs. But investigation, more information the better, is key for being able to make sensible decisions around what that escalation might look like. The more information you have, the more able you may be to choose parties where recovery may be possible. You would obviously want to be able to not spend too much in those cases. You don't want fought cases for 3 years in relation to your litigation or enforcement. But you also want parties who have funds and are able to pay awards if you generate them. And the combination of those things may not lead to a program that's making money, but will certainly lead to a more effective one, and one that is potentially cost effective. But can we go further than that? Well, actually, can we look to choose cases in order to drive more generation from a monetary point of view? Well, same principles really apply. Mostly, when you enter into enforcement, you'll decide what the most important thing is that you want out of that enforcement. Do I want to stop the activity? Is that absolutely commercially essential because there's significant sales going on particular websites that are stopping your sales going through or are irritating a very key partner? Of course, if the speed of obtaining a swift relief is absolutely key, then and some form of interim relief isn't available for whatever reason, then the likelihood is that you will want to use some form of takedown if we're looking at a marketplace or a social media issue, or you'll want to settle any kind of case swiftly, and you may be willing to give away the monetary benefit that you might be able to achieve from a full decision or pursuing the case to a conclusion. However, if the infringement is not as commercially important, such that the speed of resolution is not so key, then there's no reason why you couldn't focus more on the potential monetary benefit of pursuing the enforcement more. So it's about choosing the right kind of case. No point in spending a lot of money on enforcement if that party can't afford to pay, even if you get a judgment. So make sure that you're investigating, make sure that you know the strength of your case, make sure that you're in a position to work out if the potential recovery is worth the effort, and then only pursue those cases where that recovery may be significant. In the UK, we have increasingly over the last few years a lot of different options in relation to your formal enforcement or your litigation. I mean, let alone your lower level options with UDRPs, domain disputes, with notifications, takedowns, etc. But even in relation to escalation in the UK, we've now got a significant range of options, including some of you will be aware of the way in which IPEC, the Intellectual Property Enterprise Court, works. the UK is historically a very expensive place to litigate in relation to intellectual property and tangible assets. And IPEC introduces a swifter and more cost-effective route towards litigation. And it also has cost awards which are capped at a certain level, and damages that are capped, albeit they're capped at £500,000. And so for most trademark cases, it's a sufficiently high cap to be attractive. If you have a slam dunk case, a very clear cut case, and it's a simple matter, and the other side may well be defaulting potentially in relation to the case, depending on the nature of that party, you can run IPEC cases within the costs caps and potentially obtain a costs award and a damages award that outstrips the amount of money that you put into the case. But again, that's not of any benefit if the party in question is not able to pay the judgments. There are also potentially difficulties depending on the jurisdiction of the infringer. If it's actually a Chinese or a Korean infringer, then there may be significant complications in both serving and enforcing any potential judgment against that party. But even in relation to more significant litigation in the UK, there are increasingly a range of options that can make this a source of income rather than a straight cost drain. On this side, we mentioned DBAs, damages-based agreements. These are things that historically have not been very common, but increasingly are available to the rights owner. We as a firm are running a number of infringement cases, passing off cases relating under a DBA. Now, of course, the case has to be a very strong one, but where you can arrange that kind of situation, of course, it gets rid of a significant amount of the cost risk associated with the case. And where the infringement is significant and the party in question has the ability and the funds to potentially pay, it could lead to a significant recovery. Increasingly, there are other options, third-party funding. There's different types of insurance. Before the event insurance, often uncommon in relation to intellectual property, but you have seen it. So insurance that potentially covers infringement actions and other enforcement in relation to your intellectual property. After the event insurance, which is more common to cover fees for specific cases in relation to lawyers and the possible exposure to costs awards on the other side. And in those circumstances, the potential to effectively fix your cost entirely by the combination of an after the event insurance with a damages-based agreement can make litigation a potentially much more attractive option for a brand owner. Of course, the case has to be very strong. And again, I come back to obtaining suitable information to be able to make decisions as to which cases will be the ones to run in this particular way in order to leverage potential recovery. As an aside, these options are becoming more and more complicated in relation to UK litigation, and we tend to one of the key things is understanding which of these options to actually take. And for those who are interested, we have a Bible in relation to these different litigation options that Jeff Stewart, our head of litigation, prepared. And I'm more than happy to share with you if this is of interest. But of course, an enforcement program isn't only about the UK. Choice of jurisdiction is absolutely key if we're looking at potentially monetizing enforcement. And the cost levels vary a significant amount in different jurisdictions, as do the behavior of infringers and the behavior of the courts. Germany is a very attractive jurisdiction for enforcing brands, and has been for some time, mainly because it is a very favorable jurisdiction for brand owners. The level of decision in favor of brand owners is very strong, and the ability to be able to obtain injunctions and obtain decisions very quickly from the German courts means that infringers know that when a party is sending a letter to them and suggesting that they're infringing, they are more likely to go ahead with it with any kind of litigation, because the cost involved is relatively low, and the potential decisions are usually very favourable. Well, now, again, similar issues apply. Obtaining judgments is one thing, but enforcing them can be another. But the fact that parties are more likely to settle, but coupled with two other things relating to cease and desist practice in Germany, makes it a very attractive and potentially lucrative place to conduct an enforcement program. In relation to costs, if not damages, in Germany, there is a standard scale of costs that are awarded by the courts. This varies from where the claim is said to be worth around 10,000 euros. The costs award for a cease and desist letter from a German court will be 725 euros. If the claim is worth 250,000 euros, that same cost award can be 2,700 euros. And because parties know that the court system is favourable and know that there is relatively standardised recovery, they are also more likely to agree to stop their activity and pay those cost awards even at a relatively early stage. That, coupled with the fact that these cost awards tend to come with a penalty clause attached to them with the undertaking that's signed by the party in question, where with a penalty for breach of that undertaking, and a penalty roughly of the level of 10 or 20 or 25,000 euros for breaching the undertakings, suddenly a program of cease and desist and recovery can actually make money. Again, the parties have to be able to pay, and again, investigation will be key to make sure you're choosing the right infringements and the right parties. But at a relatively low level, an enforcement program there can be relatively lucrative. My last comment, and probably the most important one, is the availability of ACPA actions in the United States. Anti-cyber squatting Consumer Protection Act actions. This is a specific statute relating to online infringements. And the huge benefit of this bit of law, and I think most of us as lawyers in other jurisdictions would wish we had equivalent provisions elsewhere in our jurisdictions, is that statutory damages are applied to the infringement. But more importantly than that, in relation to this type of use, you do not have to prove that there have been sales in the United States. You do need to be targeting the action at websites that ship products and ship infringing product to the United States, but you do not need to prove that the sales have actually been made. In addition, the decisions relating to this statute have shown that service out of jurisdiction can be done electronically, which is a significant practical saving over and above a lot of other litigation. In addition, if you're dealing with offshore parties, so Chinese or Korean or even European parties, you can include multiple websites originating from multiple parties in a single action. And this can make this a very, very effective tool. If you couple that with the fact that in relation to online sales, the courts in question are able to freeze assets existing in, for example, PayPal accounts associated with these websites, then suddenly this becomes an extremely attractive avenue in relation to enforcement. And whilst it is a US statute, of course, it's because of the nature of it being online infringement, it doesn't necessarily only apply to issues that you may have in the US. Often these websites will be targeting many jurisdictions. Now, of course, for this to be very lucrative, it needs to be combined with sort of modern practice from a management of those cases as well. And we are increasingly seeing firms who are specializing in these types of actions take these cases on a no-win, no-fee basis. They're willing to do that because the courts have shown that they are willing to enforce. Most of the cases are dealt with by way of default judgment, meaning they're not fought to a conclusion, and the statutory damages awarded by the courts can be fairly significant. a relatively recent case for Burberry. The courts awarded a $2 million default judgment, not all of which was recovered through PayPal, but a significant amount was recovered through PayPal accounts. And in this statute, the courts are also able to transfer domain names as part of this, including domain names that don't specifically relate to the brand if they've been used on websites that have been involved in the counterfeiting activity. In that Burberry case, over 600 domain names were transferred in the default judgment. But there have been many judgments in the six-figure area, and a number of brand owners are starting to use this as a real income generator in relation to their enforcement programs. And it's a fantastic tool, and one, again, to be used as part of an overall program, but one which can start significantly shifting the financial issues around a good program. Obviously, it requires, again, really good investigation, really good information. Obviously, for it to be worthwhile, the volume of infringement issues that you're encountering need to be fairly significant. But this can be a real game changer in relation to enforcement. Probably my last main point is to talk a little bit about licensing. I mean, Esther talked a lot about the potential for generating income through brand licensing. It's unusual for brand owners to look at infringers or counterfeiters and think, well, there's a licensing opportunity. It's rare that the straight monetary value of, for example, licensing a party to continue with the use is deemed to be valuable enough to outweigh the benefit of stopping that party from using. However, there may be circumstances where you want to consider that. It may feel a little bit off the wall, but where might you do that? Perhaps if you're a slightly smaller business and the infringement is in a jurisdiction where you yourself are struggling to gain a foothold, why not license the party and obtain some money for it rather than go down the route of formally stopping it? If it may also, the infringing activity may also identify opportunities. Does it fall within the scope of an IP licensing or an IA licensing strategy? If you don't have a licensing strategy, maybe it would trigger the need to have one and see whether it may be in line or not. And if it is in line with your licensing strategy, it may well be that you don't want to license the infringer, but it identifies a real opportunity to find a potential third party to license to them, if it's not a market which you feel like you can exploit yourself. So, mindful of the amount of time that all of you have spent with us during this summit, and just some final thoughts, and you'll see that we've got quite a lot of film references through these slides, probably reflecting my particular interest in this area. It is difficult to make enforcement work from a straight monetary point of view. It is difficult, but it's not impossible. And my feeling is that the non-straight monetary benefits of enforcement speak for themselves, but they are often difficult to justify internally. Kelvin and Fernando, in relation to valuation, if you can obtain proper valuations of your brands, actually the importance of having the right IP assets, the right IA assets more widely, the right enforcement program can significantly impact on that valuation. It can significantly impact on the potential to have a good licensing strategy or a good licensing opportunities. But you can make an enforcement program more cost effective, better monitoring, more strategizing, some standardization, and in particular by ensuring that the information that you have is as good as possible and that you're selective about the cases that you pursue if obtaining some form of monetary value is important to you. And actually there are one or two options, including the wider litigation options in the UK that are available, programs in Germany, and in particular the ACPA actions that could shift an enforcement program from being effective and cost effective and providing some value to being a program which actually could generate money for you in the legal team. It's not an impossible thought. And with that, I end my presentation, and thank you all for listening, and hope you've really enjoyed the summit today.
Wonderful, thank you, Julius. Really great, great presentation there. Lots of great questions coming in as well. So if I could possibly ask you just to stop screen sharing there and have your camera to screen, we'll cover a couple of questions.
Perfect.
Now, first of all, do you think that parties, including competitors, should combine forces more for the purposes of brand enforcement? For example, joint ACPA lawsuits where multiple brands are targeted by common parties.
Yes, absolutely. I think it's a really good point, and definitely something that brands should be thinking about doing more. The ACPA, if you've got enough volume for yourself, I think works pretty well even without joining forces. But if you have slightly fewer issues, definitely the economy of scale of joining with another party can be helpful. But also, frankly, the ability to join forces, share cost, but also apply more pressure and appear more aggressive with a group of brand owners is definitely a good strategy.
And there's a two-part question here on escalation. Part A, as part of the process, you described investigation and escalation. What are the factors you would consider that point towards a good potential target for escalation?
So I think if we're talking about escalation where we're looking to generate funds, the obvious point is that they need to have money. It sounds like a trivial thing to say, but we need to find a party, we need to be able to find them, and you need to be able to find them and understand that they're in a financial position to be able to pay as and when we obtain judgment. So that's got to be the first point. Second point is usually where they're based. So depending on if the ACPA doesn't apply, the ability to enforce in certain jurisdictions will make them more or less attractive to different types of enforcement activity.
And you mentioned where they're based. The second part of the question is actually, in the UK, how do I choose the right forum or option for escalation?
So a really good question. I think very much depends on the nature and extent of the case. So there are a few different things, and Jeff and our litigation team will always be looking at this on any kind of dispute in the UK. What will be the right route? Obviously, value of the claim. So if this is a massive potential deal, then that might rule out some of the lower court options in view of potential recovery. What we're trying to achieve out of it and how quickly we want to achieve it, our own budget in relation to being able to apply, and how strong the case is, but also who the other side is, whether they're more likely to default or not, are all variables which will feed into the right forum in the UK.
Let's try and squeeze in three quick questions just before the virtual drinks. The first one being, after the event insurance, great that it brings certainty to costs, but feels like it could be prohibitively expensive just to buy the policy. Can you give me an idea of the scale of the premium?
Yeah, it varies, of course, depending on the case, depending on the potential liability. But I've seen them in the £20,000 to £30,000 range, not insignificant, but potentially manageable. Obviously, the insurers make an assessment of the case. So the stronger your case is, the lower the premium usually is. But it usually is viable if you have a strong case and you're just wanting to cover that absolute eventuality where everything goes wrong for whatever reason in the case, just to make sure that you're not covering the full cost of a high court case on the other side. So stronger the case, the better, but it can be a viable option. Will depend on the circumstances of the case.
And second last one, you mentioned that historically the primacy of settlement injunction has outweighed any focus on monetary benefit. You'd think companies would naturally think of both. What's the reason for lack of focus on financial return?
It generally hasn't been the reason for the enforcement. So it isn't seen as especially in the brand world, hasn't been seen as a potentially lucrative thing in and of itself. There are whole rafts of patent trolls who are obtaining patents in order to obtain monetary judgment. That's less the case in relation to brands and trademarks, although we have seen a little bit of that over the last 2 or 3 years. So it hasn't seemed to be particularly lucrative. And in general, what the brand owners are trying to do is protect that even more intangible aspect of their brand by preventing the use, and that has been the focus, and it just has meant that the primacy of obtaining a financial judgment hasn't really been there in relation to the sort of focus and intent in relation to the enforcement.
And final thoughts / question before we get to virtual drinks. ACPA in the US still feels rare. The direction of travel seems favorable, but at what rate will this become more widespread?
I think it is becoming so. It's been around. I actually don't know the exact date, but I know from my own experience that these cases have been run for at least the last 8 years. And I know firms that have obtained judgments in excess of $10-20 million in the last year or so in relation to these cases. So I think as the case law has grown over the last 2 or 3 years, it is becoming more common way to proceed, and I think it will continue to. And I hope that more equivalent bits of legislation appear around the world to kind of even the playing field a little bit between brand owners and infringers.